यंग लॉयर्स को ड्राफ्टिंग करते वक्त अक्सर एक डिफ़िकल्टी आती है। जब मैंने कुछ यंग लॉयर्स से बात की तो लगता है ये डिफ़िकल्टी वो फेस करते हैं और शायद सभी मेजॉरिटी फेस कर रही होगी। वो ये कि जो सेकंड रूल ऑफ ड्राफ्टिंग है कि ड्राफ्ट ओनली एंड ओनली मटेरियल फैक्ट्स। तो मटेरियल फैक्ट्स कैसे आइडेंटिफाई करें, इस वीडियो में वही बात मैं आपको समझाने वाला हूं। See, it's not difficult. There is a test to identify material facts. And you see, if you don't plead material facts, you will not succeed. इतने महत्वपूर्ण होते हैं वो material facts. So material facts are those facts which a plaintiff must plead in order to succeed in his claim. Or if he is a defendant, then the defendant must plead in order to succeed in the matter. Either parties, whoever is the party, must plead material facts. So material facts are a bundle of such facts which must be pleaded, which are a must to succeed before the court in any claim. Claim means a claim either for some decree or order, or if it is a defendant, then a claim for dismissing the suit. ठीक है ना? Clear up to this? Now we proceed to understand how to identify the material facts. Now when the client comes to you, you collect from him a list of facts. Number of facts, many facts. You take down instructions from him. He narrates to you his story. You note down the facts. At that time, without judging whether they are really material facts or not material facts, you just go on noting down each and every fact related to his problem. In addition to collecting the facts in this way, by way of oral narration from the client, you also collect facts on the basis of documents. There are documents which tell you some story. Thus, a totality of facts obtained from the mouth of the client as well as from the documents that he brings become one collection, big bundle of facts. Now when you sit to draft a plaint, we are now taking example of a plaint only to make things easier to understand. Now this rule applies to all kinds of pleadings, let me tell you, in all courts. Just for the sake of example, I am taking the example of a plaint in the trial court. But be it a writ petition in the High Court, or say, be it an original application before the administrative tribunal, or a complaint before a consumer forum, any other original court, this rule applies. So when you sit to draft your plaint and the prayer in the plaint, you identify the material facts in this way. What you do is, now this is a test given by a leading author on drafting. The name of the author is Mogha. In one of my videos, I have already introduced you to his book on drafting of pleadings. I hope you have seen that video. If not, please go and watch that video. So what you have to do is, you have to take each fact one by one and ask a question to yourself. If I do not plead this fact in the suit and plead rest of the facts, will I still succeed on the basis of rest of the facts? The answer is, if the answer is that yes, even without pleading this fact, you can succeed on the basis of rest of the facts, then obviously this fact is not material fact. But if the answer to the question that you pose to yourself is that no, you will not succeed if you do not plead this fact, and if you eliminate this fact, then this is a material fact which you must include in your drafting. In this way, you go on doing the same thing with regard to each fact. Take another fact, ask the same question to yourself. If I do not plead this fact, will I succeed on the basis of the remaining facts that I will plead? If the answer is yes, you will succeed on the basis of the remaining bundle of facts, then this is not a material fact. Eliminate it and plead other facts. This way, you go on asking the same question one by one with regard to each fact, and either eliminate certain facts or include certain facts as material facts. Then you get the entire list of material facts which you must include for the purpose of pleading in your drafting. Now you see, this doesn't happen always in this way, the way I explained. It may happen in the very initial years of your practice. But as you become mature in your practice, as you go on becoming more and more experienced, you will be developing a sense here whenever you collect material facts. Whenever you collect facts from your client, not material facts from you will develop a sense, and instantly you will be in a position to recognize whether a particular fact is material or not. Now see, there is no magic formula. Depending upon the prayer that you are making in the plaint, a particular fact may become material or may not. I'll share with you a very interesting incident that happened yesterday at my office. I was explaining this concept to an intern in my office, and after understanding it, she quickly gave an example. It was a beautiful example that she gave. She said, she summarized it by giving that example. She said, okay, sir, this means that if I want to tell my mother that I met you, that she met me, I need to simply tell her that I met you. Right? I need not tell her that I left my room at this time, I took this route, then I followed that path, and then I reached sir's office at that time, and then sir was sitting or standing, and then I said hello. All these facts I need not tell her. I should simply tell her that I met sir at his office, that's all. And that's a material fact. She beautifully summed up, she beautifully made out that point, and I really appreciated her. So that's the thing, my dear friends. So beautifully she gave that example. She quickly grasped that point. What is a material fact? And I hope you also have grasped that point by now. Not difficult at all. Thank you for watching.